to the session on Minimum Wages Act. First of all, I would like to brief you about the different wage theories on this occasion. A minimum wage, as defined by the committee, it says the wage must provide not only for the sustenance of life, but for the preservation of efficiency of the worker, and also for this purpose, the minimum wages must provide some measure of education, medical requirement and amenities. In other words, the wage should provide for sustenance of worker's family and his efficiency, the education of his family, and for medical care, etc. The question of determining the minimum wage has been very difficult here, because what happens is that conditions vary from state to state and industry to industry and even worker to worker. The standard of living cannot be determined accurately, and moreover, it's not uniform, because the standard of living varies from state to state. As a matter of fact, it may vary from within the state also, from district to district, city to village, and city to town, and various factors are there. And the size of the family, that's also a difficult thing. Then how it should be determined has been a question of, is a challenging question. However, the principles of determining minimum wages were evolved by the government and have been incorporated in the Minimum Wages Act 1948. The Minimum Wages Act aims at certain extent the factors for determining the minimum wages to a worker. Under this category, broadly there are two types. The statutory minimum wages prescribed by the respective state governments and revision thereafter from year on year, that's one way. Other thing is the minimum wages determined by the courts. Many times the courts also have determined the minimum wages, and they are also giving a lot of guidance in this factor. Now there is one fair wages. According to Committee on Fair Wages, it is a wage which it is above the minimum wage but below the living wage. Here the lower limit of the fair wages is obviously the minimum wages. The upper limit set by the capacity of the industry to pay. This is another consideration which on account of the fair wages is considered. However, between these two, the actual wages should depend on considerations of the following factors. Number one, the productivity of labor, it has to depend on the prevailing rates of wages in the same or neighboring states, regions, is also very important. The prevailing rates of wages in similar industries, that's another factor. The level of national income and distribution, that's also one of the factors. And place of industry in the economy of the country, that's also very important, because some of the industry in the economic industry can be at a lower esteem, or maybe at a higher esteem, or at a medium esteem. It depends on. These are the factors to be taken into account. Now coming to living wage, the company has recommended by the committee as a fair wage and has ultimate goal as a wage policy. Hence the living wage has been determined as one which should enable the earner to provide for himself and his family not only bare essentials of food, clothing and shelter, but as a measure of physical comfort, including education for his children, protection against ill health, and requirement of essential social needs, and a measure of insurance against some more important misfortunes, including old age. In other words, living wage was to provide a standard of living that would ensure good health to the worker and his family, as well as a measure of decency. Living wage is to be determined by keeping in view the national income and capacity of the industry to pay. This is only important criteria. The committee was of the opinion that although the provision of living wage should be ultimate goal, the present level of national income did not permit the living wage on the basis of standard prevailing in advanced countries. The other thing, the goal of achieving living wages has some stages. Firstly, the minimum wage is determined by the working class and paid, and secondly, the fair wages established in the region come industry or community or come industry. Thirdly, the working class to be paid living wage. This is how the steps of fixing has to be taken into account. The minimum living wage may be somewhere between the lowest of the minimum wage and highest of the living wage. It depends on the bargaining power of labor also. Many times it depends on that. And capacity index to pay, that's another relevant factor. National income, general effect of such levels in the neighboring industries, the productivity of labor, the place of industry in the economy, prevalence in similar industries and many things. Another concept is what is called need-based minimum wages. In the Indian Labour Conference in the 15th session in 1957 itself, suggested that the minimum wages slowly upgraded to the level of need-based minimum wages. Broadly, for calculation of the broad-based minimum wages, some amount of work was done, and then they said some parameters they set for the calculations. They said a standard working family should consist of 3 consumption units for the earner. This here the earnings of women, children, adolescents should be disregarded, right? Then the minimum food requirement should be calculated on the basis of intake of 2,700 calories as determined. The clothing measurement also have been estimated as per capita consumption of 18 yards per annum, and average workers family about 72 yards in a year. In respect to housing, the norm should be the minimum set by the minimum rent charged by the state government in any area of houses provided under subsidized housing schemes for low-income groups. Fuel, lighting and other miscellaneous items of expenditure should constitute 20% of the total minimum wages. Since the ILO, several agencies, including trade unions and government, worked out, but there have been no consensus due to various reasons, and it is still remaining. This is exactly the position, but somehow in the sector of organized sectors, because of the bargaining power, because of the trade union movements, bargaining power, they have already, many of the organized industries, they have come out of the need-based minimum wages and even beyond that also. Even the middle companies also, they have reached this level. The only thing is that the unorganized level at unskilled labor, still the problem persists and yet to be seen. Now the Minimum Wages Act, this act is brought into force in 1948. This is the only legislation in India which prescribes the wages. Otherwise, no other legislations prescribe the wages. This is the only legislation which prescribes the wages. Employer means any person who engages directly or through another person on behalf of himself or any other person, one or more persons, he is an employer, just like that. So even for instance, the schedule of the industry can be expanded to domestic also. Even a house owner is an employer if he engages a maid servant to do his household work. An employee means any person who is employed for hire or reward, manual, clerical, etc. And then may have includes an outworker. He is also, outworkers are also covered under the Minimum Wages Act. Outworker conflict, I already told you, the people who work sitting at home but carries on the activities of the principal employer sitting at home, they are also covered under the Minimum Wages Act. Now if you look at the definition of employer, it says only any employer. It means the category expand depends on the growth of business activity and social needs of the people. It writes from start with any person employs directly, indirectly, and in respect to which the rates have been fixed under the Act. So it covers everybody, right from individual to a mid-sized company or even big corporate, for everybody this is covered. Employee definition, we find that a wide coverage. The arms of the Act is explainable. One who is engaged for any work, unskilled, skills remain clerical. It includes under direct employment or through other contractors in the scheduled category. It is important to note that outworkers are also covered, and this is the coverage. Now, fixation of minimum wages is broadly procedure under Section 3 of the Act. For this purpose, the state or the central government appoints the minimum wages advisory boards they constitute. This advisory board consists of representatives of the trade union, representatives of the employers, respective employers, and the government. They sit together and then formulate, discuss, and decide and then give a recommendation to the state government or the central government about their proposal to fix the minimum wages as they feel fit. Of course, when the advisory board takes into account while fixing, they have taken into account all various parameters, including hearing the employer's point of view and their capacity to pay, and the wages prevailing neighboring states. All these things they need to take into account and ensure that the minimum wages shall not be less than the minimum wages already being paid to other scheduled categories. So at least that should be ensured. On these lines, they give a recommendation to the state government or the central government. The central government or state government, they may have choice. In the sense, they may accept and they may not accept, they may revise, they can do anything. But only thing is, the entire thing is a judicial one, because many instances are there where the order of the government or the state government or central government fixing the minimum have been challenged by either the trade unions or by employers also. Hence, it has to be judicially transferred upon. That is very extremely important, otherwise they can go to court. While fixing the minimum wages, it can be that different rates, minimum wages fixed for, it can be for scheduled employment number one, then different classes of work in the same scheduled employment. It can be right from unskilled to high level, including up to the level of manager. They can fix the minimum wages. Then adults, adolescents and apprentices, they can fix differently. Then different localities, even in the particular state, they can categorize the entire cities and towns in different categories, depending on the size of the city and the cost of living over there. They can divide into category 1, 2, 3, 4, depending on the geographical location, and then they can fix the rate based on that also. And the minimum wages can be fixed per hour also. It can be fixed per day also. It can be per month also, or such a wage period also that will be prescribed. The Act permits the advisory board to fix as such. So any very fixed rate employs the appropriate government in respect to scheduled employment may consist of basic rate and special lines, or at a rate adjusted such intervals as the appropriate government may feel fit, or the basic wages with or without cost of living, that also can be done. The all-inclusive rate also can be do it, allowing the basic wage and rate of cost and the cash value of constitution if any. It can be. So either it can be basic and special lines to take care of the cost of living that behave, or basic rate with or without cost of living also can be fixed, and all-inclusive also can be done. So it depends on the state advisory board, how they recommend, how they do it, it depends on them. But these three choices are available to advisory committee to fix all these things. The procedure I told you already, it's a question of constitution of the central advisory board and state advisory board, and they deliberate around and then evaluate the fixation of wages in a very as professionally as possible with sufficient data and logic. They need to advise the government on this. Then payment of minimum wages. In respect of minimum wages, the employment without deduction except an authorized such kind have been prescribed. The notification under Section 10 forces any employer shall have to pay the prescribed minimum wages, not less than prescribed minimum wages. He has to pay, and he cannot pay anything less than the prescribed minimum wages from time to time. Then the Act also specifies here the fixing hours and normal working day, etc. The Act also stipulates the hours of work, the rest interval, weekly holiday, and then payment of rate not less than the minimum wages, and minimum wages amount not the double the rate of for more time, and those are similar in the provisions of the Factors Act. This also provides for overtime and double rate, etc. So if you see the working hours and then the weekly off and payment of is exactly similar to the provisions under the Factories Act. Then wages for two or more classes of work. If an employee does 2 or more class of work, one per day, let us say he does half a day for unskilled work and half a day for semi-skilled work, then he should be paid proportionately for the work what he has done. If he has done half a day for unskilled work at the rate of half the skill, if he has done that semi-skilled work for next half day, he should be paid at that time. It is all the provision is there. It is quite possible and it can be done. Then here, is an employer who is not paying the basic wages and dividends and salaries separately fixed under, but he is paying wages more than the prescribed wages, he is committing any illegality. Many times the question has arisen in the sense that if the minimum wages, if the total salary, if the total wages is paid is more than the minimum wages, more than the prescribed minimum wages, does he committing any illegality? No. The minimum clearly says that total remuneration shall not be less than the prescribed minimum wages. And the Act also provides the minimum wages can be split into basic wages, cost of living allowance, and therefore, where an employee is paying total sum which is higher than the minimum rate of wages under the Act, includes cost of living allowance, etc., and is not committing any illegality. Where, what is the position of employee who is unable to pay minimum wages under the Act? It is very clear, an employee is bound to pay minimum wages as fixed by the government. Otherwise, whether it is irrelevant whether he has got capacity to pay or not, that is not the concern at all. When you engage a person, you have to ensure, irrespective of your financial strength, you need to pay the minimum wages. Now, what is the procedure for an employee to follow to make claim under the Act? This also stipulates, supposing an employee having a claim that he has not received the minimum wages or less than the minimum wages, or he has not received the minimum wages, he has to make an application to the authority. Such application can be submitted either on himself or by any trade union. Then the appropriate authority shall immediately summon and take the matter into account, and it will conduct the proceedings. And in fact, the authority has got powers to pay even penalty up to 10 times the difference. That much of authority he has got over and above payment of difference. The authority can award the compensation up to 10 times the amount of the difference. The amount directed by the payment authority shall be recovered, as if it is a fine imposed by the magistrate. Here, every direction authority will be final under section 20 of the Act, very important. So here the proceeding is almost something like a judicial one, and the order passed by the minimum authority is final and everybody has to obey it. The difference between Payment of Wages Act and Minimum Wages Act, difference is that Payment of Wages Act regulates the mode of payment and that does not prescribe the wages should be paid to an employee in organization, whereas the minimum wages prescribes the rate of wages to be paid in the scheduled industries. Hence, the Act is covered under Minimum Wages Act. Automatically, the Payment of Wages Act also becomes applicable. Now, I'll just take you through just one or two case laws in the subject. In the Supreme Court held that the payment of wages less than the minimum wages if a person employed him in family relief is violative of even Article 23. He said it's a constitutional violation if you pay less than the prescribed minimum wages. In case of Dina versus Union of India, it was held that the labor taken from prisoners without paying the proper minimum wages it amounted to forced labor, and again it is violative of Article 23 of the Constitution of India. So the prisoners are entitled for payment of the reasonable wages, not less than the prescribed minimum wages, and the current court has to direct and enforce it. The capacity of the trade or India has no consequence whatsoever on question of payment of minimum wages. It's a matter of fixation of wages. Capacity is irrelevant to what in Germany the wage required by the employee is important and survivable. The financial capacity of the employer again is no consequence. Again, that has been held by Bombay High Court in the case of Kanak Industries in 1994 itself. Then minimum wage is a very good decision. They say that minimum wage is not contractual, but it is a statutory. Failure to revise is not only statutory violation, but it has got breach of fundamental rights under Article 23 of the Constitution. So this serious observation was also made by Planters Association versus State by Kerala High Court. A duty is therefore cast on the state government by provisions of this Act and also Article 23 to fix the minimum wages and revise the minimum wages from time to time. So minimum wages can be split into allowances. Hence EPF contribution need not be on the minimum wages. When I discussed with you on the Provident Fund module, I spoke to you about this, that the minimum wages can be split into different wages and EPF contribution need not be paid on the minimum wages. That's very, very clear. It has been held by Charlotte Hotel by Bombay High Court here. There is no compulsion the basic wage should be equal to minimum wages. It is also held in by AP Manpower Services separate tribunal, and even in case of EPF in under Section 78, the appellate also has held the same view and has taken. In the case of the very, very leading case in this minimum wages, in the case of air freight case versus the state of Karnataka, the Supreme Court has said very clearly that if the employer has been paying more than the prescribed wages, then not only he is at liberty to split into different wages, but the additional day runs, etc., he need not pay at all, because that's totally illegal. Because they are already paying more than the minimum wages. The question of paying VDA separately or combined with this is totally irrelevant. Because here the labour authorities put up a case against air freight to say that the VDA declared by the government is not included. Hence this case was taken up. The Karnataka High Court held in favour of the Labour Department, but the Supreme Court reversed the decision to say that no, it's not correct. When the employer is paying more than the minimum wages, the question of paying additional VDA or separate VDA does not arise of no consequence at all. The Bombay High Court also has had the same case in the case of Auto Cars Aurangabad, and he says the total basic and VA has to be taken into account. When total basic and VA has taken into as one evaluation, then with the question of this will not come. While can different taking into account basic specialized personal pay is proper in the light of the judgment of Apex Court in the air freight case. Same view has been taken here also. The tribunal has held that minimum wages can be split into alliance for PF contribution in the case of delayed services or PF Indore. It has been held, and it is a reiteration of the same judgment what has been told earlier. So this is about the minimum wages. So thank you.